So glad to have you back. Today, we're diving into the often murky waters of the American legal system. Specifically, we're looking at two powerful tools that can help protect your civil rights: 42 U.S.C. Section 1983 and Section 1985. Now, I know what you're thinking. Agnes, those sound like the serial numbers of robots sent to audit my taxes, and you wouldn't be entirely wrong. These laws can be complicated, but trust me, they're worth understanding. In a nutshell, Section 1983 allows you to sue government officials who violate your constitutional rights. Think crooked cops, biased judges, or vindictive school administrators, anyone acting under color of law. Meanwhile, Section 1985 tackles conspiracies to deprive individuals of their civil rights. This could involve government officials working together or even private citizens teaming up to discriminate against others. These laws are crucial because they provide a way to hold those in power accountable. They're a safeguard against tyranny and a reminder that no one, not even the government, is above the law. Now, let's talk about a real-life example of these laws in action. Picture this: Wood County, Texas, a place where justice apparently takes a holiday. Our story involves Terry Bevill, a veteran police captain who dared to question the integrity of his superiors. When a colleague faced trial, Bevill, acting as a private citizen, filed an affidavit expressing concerns about the judge's impartiality. What followed was a masterclass in official retaliation. Bevill was pressured to resign from his job, slapped with a bogus perjury charge, and subjected to humiliating court-ordered restrictions. It was like something out of a bad legal thriller, except this was real life. Bevill, however, refused to be bullied. He fought back, filing a lawsuit under Section 1983 and Section 1985, alleging a conspiracy to violate his civil rights. And guess what? He won. A jury saw through the charade and awarded him a whopping $21.35 million in damages. The Bevill case is a shining example of how ordinary citizens can use the law to fight back against powerful interests. It's a testament to the idea that even in the face of overwhelming odds, justice can prevail. But what about conspiracies involving private citizens? That's where Griffin v. Breckenridge comes in. This landmark case, decided by the Supreme Court back in 1971, involved a group of black individuals who were brutally attacked by white men in Mississippi. The attackers mistakenly believed their victims were civil rights workers. The Supreme Court ruled that the attackers could be sued under Section 1985, even though they weren't government officials. This was a huge victory for civil rights, as it established that private citizens could be held accountable for conspiring to deprive others of their constitutional rights. The Griffin case remains incredibly relevant today, particularly in the context of family court. Imagine a scenario where an abusive ex-spouse colludes with their lawyer or even a corrupt evaluator to gain an unfair advantage in a custody dispute. This type of conspiracy, while often hidden from view, can have devastating consequences for the targeted parent and their children. Let's face it, the family court system can be a bureaucratic nightmare even at the best of times. But for some parents, it becomes a twisted labyrinth of injustice, where corruption, bias, and outright lies reign supreme. Imagine a system designed to protect children being weaponized to punish one parent and reward the other, often with little regard for the truth. We're talking about cases where judges rubber stamp false accusations, evaluators churn out biased reports, and lawyers prioritize winning at all costs, even if it means destroying families. It's a system where the pursuit of justice is often overshadowed by personal agendas and the relentless pursuit of profit. Section 5. Recognizing the signs. Is there a conspiracy against you? So how can you tell if you're caught in the crosshairs of a family court conspiracy? Well, there are some red flags to watch out for. Are you being consistently ignored or overruled by the judge, even when you have clear evidence to support your case? Are you being subjected to unfair rulings that seem designed to punish you or limit your access to your children? Are you dealing with a court-appointed evaluator who seems biased against you or overly chummy with your ex? These are just a few signs that something might be amiss. It's important to remember that while not every negative experience in family court is indicative of a conspiracy, it's crucial to trust your instincts and be aware of the potential for abuse within the system. Section 6. Fighting back. How parents can use the law to protect their rights. The good news is that parents facing such injustices are not powerless. Just like Terry Bevill, you have legal options. Section 1983 and 1985 provide a pathway to hold accountable those who abuse their positions of power within the family court system. They are tools to expose corruption, punish wrongdoing, and hopefully deter future misconduct. Of course, pursuing legal action against judges, lawyers, or court-appointed professionals is no walk in the park. It's a daunting task, often requiring significant time, resources, and emotional resilience. But for those facing the prospect of losing their children or being subjected to continued injustice, it can be a fight worth having. Section 7. Documenting the truth. Evidence is your greatest weapon. Now, if you're considering taking legal action, remember, evidence is king. In the immortal words of any lawyer worth their salt, document, document, document. Keep detailed records of everything. Every interaction with the court, every communication with the other parties involved, every instance of bias or unfair treatment. Save emails, record phone calls, where legal, take photos, and keep a journal of events. This meticulous documentation will be your greatest asset when building your case and proving the existence of a conspiracy. Section 8. Identifying the players who is part of the conspiracy. Next, you need to identify the conspirators. This may seem obvious, but it's crucial to pinpoint exactly who is involved and how they are working together to violate your rights. Is it the judge who consistently rules against you? The evaluator who recommends limiting your custody? Your ex's lawyer who seems to be calling the shots from the sidelines? Remember, conspiracies thrive in secrecy. Connecting the dots and exposing the individuals involved is essential to dismantling their operation and seeking justice. Section 9. Seeking justice. Taking legal action against the perpetrators. Once you have gathered substantial evidence and identified the key players, it's time to lawyer up. And not just any lawyer will do. You need someone who specializes in civil rights litigation, particularly in the context of family court. Look for attorneys with a proven track record of fighting for parents' rights and holding corrupt officials accountable. Remember, taking legal action is a marathon, not a sprint. It requires patience, persistence, and a willingness to fight for what you believe in. But with the right legal representation and a mountain of evidence on your side, you can level the playing field and seek the justice you deserve. Section 10. Breaking the silence. Sharing your story and empowering others. Finally, it's vital to remember that you're not alone. Sadly, countless parents have endured similar nightmares within the family court system. Sharing your story, while undoubtedly difficult, can help raise awareness about these issues and empower others. By shining a light on corruption and abuse, we can work towards reforming the system and ensuring that family court truly serves its intended purpose, protecting children and promoting their best interests. So, speak your truth, connect with other survivors, and let's fight for a fairer, more just family court system for all.